Everyone. My name is Caitlin Elam, and I am joined this afternoon by my co-host, Ashton Smith. Today, we are continuing an effort by Lewis Thomason to bring you seminar materials each month, specifically related to the construction law practice and what is pertinent and relevant to what you all do every day. Today is a little bit different because we are going to focus on employment law. While many of you are design professionals or contractors who may be interested in different things related to your actual practice, one thing is all of you are likely employers. Whether you're a small employer or a large employer, there are still various topics you need to be aware of in the middle of the COVID-19 crisis. So that's why Ashton and I are here today to talk to you about that reconstructed employment law considerations stemming from the COVID-19 crisis. As I said before, my name is Caitlin Elam. I am a shareholder in Lewis Thomason's Knoxville office. I've been with the firm my entire career. I practice in the area of employment law. Specifically, I represent private employers and public employers such as school districts related to various employment issues, whether it stems from discrimination claims or employment contracts, employee handbooks, general consultation. It's what I do on a daily basis is advise employers on how to adequately proceed forward in whether it be administrative claims or litigation as well. So I'm joined today by Ashton Smith. Ashton is new to Lewis Thomason as of March, April. He started with us in the middle of a pandemic. So this is all Ashton really knows right now as it pertains to our firm. Ashton is not new to the practice of law. However, Ashton worked as in-house counsel for a healthcare company specifically related to transactional matters. So Ashton is very keen to detail, and he has joined our construction law practice in Nashville, working with David Garst and Wally Irvin, who I'm sure many of you are familiar with. So I am excited for Ashton to hopefully stick with us long enough to get us out of the pandemic and work with all of you on a daily basis. So what we're going to talk about today is I'm going to let Ashton get started with the Tennessee COVID-19 Recovery Act, which was a liability bill that was passed by the Tennessee General Assembly over the summer. And he's going to talk to you about some different ways to work within the act in order to protect your company from liability. Then I'm going to launch into the more boring employment basics, some different pitfalls you may find yourself as an employer during COVID. COVID is not going away anytime soon. We will be dealing with this well into 2020, and we'll be needing to be able to react to different laws, employee confidentiality and protected leave laws. I am already beginning to receive claims as an employment lawyer related to COVID liability. So it's very important that we continue to keep it on, and remember that we need to protect ourselves from all aspects of things, not just the virus itself, but claims that may arise from it. So right now what I'm going to do is I am going to turn it over to Ashton, but be sure that if you have any questions, you can put it in our chat box and we'll do our best to answer those at the end. We welcome questions. If you cannot think of a question right now, our contact information is included in this PowerPoint. You are welcome to email either of us at any time related to any of these various issues that we're going to discuss. And then I think that you all should be made aware that our next webinar is going to be November 17th, which will be presented by Preston Hawkins and Julia Hale related to unlicensed contractor issues. So it'll be more back in your wheelhouse as design professionals and contractors. So Ashton, I will turn it over to you.
All right, thanks Caitlin. I think you did a pretty good job introducing me. So I'm going to go ahead and jump right into our agenda for today. And so I'm going to be focusing my portion of the presentation on Tennessee COVID-19 Recovery Act, which, as Caitlin mentioned, was passed this summer, and it was finally enacted by Governor Bill Lee on August 17th of this year, effective immediately, except for claims filed before August 3rd. And this will run until the summer of 2022. It applies to any suits for loss, damage, or injury or death arising from COVID-19. So what does arising from COVID-19 mean? That could mean the obvious exposure or contraction of COVID-19 in the workplace. It can also mean the implementation of policies and procedures to prevent or minimize the spread of COVID-19, COVID-19 testing, investigations or reporting of COVID-19 exposures or infections or other related information. It can mean the use, provision, or donation of PPE. Can also relate to closing or partially closing to prevent or minimize the spread of COVID-19. So it's a pretty broad range, pretty much covers anything you would expect related to COVID-19. And it also helps businesses a lot in the state because a lot of insurance carriers, after the SARS epidemic in the early to mid 2000s, added pandemic exclusions into, for example, business interruption policies. There's other insurance coverage that excludes communicable diseases such as COVID-19. So this provides extra support for businesses to go about their operations. It's not business as usual, as you're well aware, but it does allow you to operate with a little bit less stress, a little bit more leeway. So one of the main ways it helps protect businesses in Tennessee is that rather than being subject to negligence claims, you're not protected from negligence. It has to be at least gross negligence or willful misconduct on the part of the defendant in order for a claim to succeed. And so what does gross negligence mean? That means a callous indifference to consequences. So if you act reasonably and you consult the CDC, you consult the Tennessee Department of Health, you implement the protocols, policies, and procedures that they recommend, you have a very good shot at being protected, and you won't be subject to any lawsuits that really are without basis. And so that's the main point of this. It
One
also,
thing
yeah, go ahead.
Ashton, is I would encourage everyone, while this statute provides some protection relative to gross negligence, as we all know, there are plenty of lawsuits that are filed out there that are not necessarily have merit. But what I would encourage everyone to do is to reach out to their insurance carrier, just like Ashton mentioned, that they've included a lot of exclusions for pandemics. But one thing we always have to remember is cost of attorneys and cost of defense. So one thing you might consider doing is always reaching out to your carrier to see, if somebody does bring a claim, even though I'm acting reasonably, not acting grossly negligent, will you provide me coverage for defense costs at least? So that's one thing to always kind of think about, especially in these types of situations, is just trying to figure out what stance is your insurance carrier going to take if you end up getting a claim.
Thanks, Caitlin. That's very good information. The next portion of the act is, rather than a preponderance of the evidence standard that you'd see in a negligence claim, which would mean, you have enough evidence to prove that your claim is more likely true than not. Now the plaintiff would carry a much higher burden of proof, meaning that you have to enable a finder of fact, being a jury or a judge in a bench trial, to form a firm belief or conviction regarding the truth of the facts sought to be established. So rather than, it's 51 over 49% likely with the preponderance of the evidence, which, you put numbers on it, that's just to help explain. Nobody uses, 51% as the standard, but the clear and convincing evidence is just a little bit higher. So that the person bringing the claim has to have really some pretty solid evidence in order to get past this standard. The last main portion of this is that you have to submit a verified complaint rather than, a standard complaint. What that means is that you have to plead specific facts with particularity from which a finder of fact could reasonably conclude that the loss, damage, injury, death was caused by the gross negligence or willful misconduct of the defendant. So with that, you have to also submit a certificate of good faith from a physician, which states that they reasonably believe that the exposure or contraction of COVID-19 was caused by an act or omission of the defendant, in this case being you, hopefully not. So that's just another way to kind of slow down any kind of frivolous claims and just give you a little bit of extra peace of mind, not to let your guard down, but just to know if you act reasonably, try to implement reasonable protocols, that you don't have to worry as much about these people coming after you with frivolous lawsuits. And like I was just kind of touching on before, this is a way to avoid liability. It's really a cost-effective defense against unsubstantiated lawsuits. We mentioned the insurance coverage before. Well, as you all know, you have to pay for that. This is a way to have a little bit of extra coverage without having to pay for anything extra, which, during this pandemic, a lot of businesses have had to have additional outlays related to PPE, related to, implementing social distancing measures, whether you have to move desks or you're improving the ventilation of your office space so that air is not recirculated and you're bringing in outside air, which, during summer, winter months is a little bit more expensive. So it helps businesses to reduce costs when you're already in an environment with additional costs. The perfection is not required, as I said. It's a common sense and good faith effort standard. So as long as you're making a reasonable effort, you're not just going out rebelling or just recklessly disregarding that we're in a pandemic, you take some reasonable precautions, you should be protected. Some examples of those precautions being telecommuting. If you're in a design firm, that's possible. If for the contractors, you have boots on the ground, that means trying to not share tools, or if you have to share tools, you're disinfecting it with alcohol wipes or some other disinfectant before sharing, disinfecting high contact surfaces, trying to minimize the amount of time where you're meeting in person, just try to limit that, or in the trailer, just trying to maximize the amount of social distance between people when you're in a trailer on a job site, just generally following the guidelines that the CDC puts out. And some of those policies and procedures, like I was just talking about, they're changing. I mean, this is a rapidly changing environment. As you're well aware, 2020 has been kind of a wild year. So I would expect that guidance will change again. We're giving you information based on what we know now and what you may have already had in place since March or April. If you have those things in place already, good. Just continue to use those policies and procedures. Just don't let your guard down, even though, I'm talking about how you have additional protection. It's important to, keep doing what you're doing in the right way, such as daily health screenings, making sure that people aren't coming in with a temperature over 100.4 degrees. You're asking the questionnaires each day when employees come in, such as, have you been told to quarantine or isolate by a healthcare provider or health department, which could be Tennessee Department of Health or a county health department, like Davidson County Metro Healthcare, or Williamson County Department of Health, wherever you happen to be. Just if you get a quarantine order, don't go into work, and just make sure your employees are aware that they should not go into work if they're under such an order. If you're exposed, face-to-face contact for 10 or more minutes with somebody with COVID-19, important to keep those people at home for the quarantine period. If anybody who's sick right now, if you have a fever, cough, shortness of breath, if you lose your sense of taste or smell, or vomiting, diarrhea, any of that, those people are encouraged to stay home so that they do not bring the sickness to work. I'm kind of repeating a lot of what you may have already heard, but it's just hammering home that, keep doing the right things there. Contact tracing which includes reporting to your local health department if you do have a confirmed infection. Hygiene rules, making sure people are washing their hands for at least 20 seconds with the right soap, or you're providing hand sanitizer, whatever you have to do just to make sure that your employees are protected. There's some more industry-specific guidance which would provide you even further protection. For example, as a contractor on a work site, OSHA has specific guidelines which you can see on the screen. I'm not going to read through all of them. A lot of it would be repeating what I've already said, but if you follow these sort of guidelines, that would be evidence that you've acted reasonably, which would possibly or probably protect you from an ordinary negligence claim, but especially for a gross negligence or willful misconduct claim under the act that's now been enacted. These sorts of steps will go a long way.
Well, and one thing to remember too is as either design professional or a contractor, you may be eligible to be considered what's called a critical infrastructure worker under the CDC, which the main idea behind all of that is that you are so critical that you can continue to work even if you've been exposed. So that's one thing, to always remain kind of an advocate for yourself in the event you are contacted by the health department and you have a whole slew of employees that are suddenly expected to quarantine. You could always mention to the health department, I'm considered critical infrastructure under CDC guidelines. And what that means is your employees can continue to work even if they're exposed, as long as they are masked. And the minute they begin to show symptoms, they are to begin isolation and quarantine. So it's always really important to keep consulting CDC guidance on that as well, because being critical infrastructure, in which many of this industry would be, in the fact that we are continuing to build buildings, design buildings, roads, what have you, or electrical, mechanical, we just need to remember you may be so essential that you can continue working even if you are exposed.
That's a great point, Caitlin. Thanks for adding that in there. The next thing would be mask policies, where I would recommend signage. Think the no shoes, no shirt, no service signs. This sort of a sign is acceptable for masks. It conveys right off the bat to anybody that comes on your job site or in your office that you are taking steps to prevent the spread, which would help you defend a claim, but also just communicate this sort of information, which can be a little bit stigmatized in some places. Attitudes and expectations may vary. So if you enforce it in a non-discriminatory manner, use signs and all of that sort of thing, that can go a long way. Some of it is it boils down to a business decision. Does the downside of requirement of masks outweigh the risk exposure? You have to think about the risks of litigation or having to close down your business if someone contracts the disease, or potential of any stigma of cases are traced back to your job site or whatever establishment. That could be a negative. So it's just important to also keep masks on hand if you're going to have a policy like this, just in case people forgot or they don't have one. It's a good way to thread the needle and avoid any confrontation regarding this important step. As far as locally, Governor Lee has extended an executive order, which means that this is now on a county by county basis, whether masks are required or not. And this is another area that's rapidly changing. So it's really important to monitor the requirement in any counties where you operate. And like I said, enforcement in a non-discriminatory manner. If you bring this up to one employee, it's got to be to anybody who's not wearing a mask. Just be even-handed but calm and firm, and like I said, provide masks for employees without one. Another way to help protect yourself is you can provide this sort of a protocol acknowledgement, especially for subcontractors to or contractors providing this to subcontractors. You really kind of make sure that they are in line and are in agreement with the protocols that you as a site manager or administrator are using for your workforce. So the key takeaways from all this is that the Tennessee COVID-19 Recovery Act, it doesn't grant absolute immunity. You still can be liable. So remain vigilant, use good practices, but just know that if you do have additional coverage compared to, July or, before this act was enacted. Just continue to use common sense business practices and you should be in good shape. And with that, I'm going to hand it over to my esteemed colleague, Caitlin.
So this is a perfect segue, Ashton, because one thing you kept saying in your presentation is implement these policies, these procedures in a non-discriminatory manner. So this is where I'm going to take you back to school on Employment 101. Tennessee is an employment at will state, which basically that means you can terminate an employment relationship with any employee for any reason whatsoever, except for a discriminatory reason. Obviously, if you have employment contracts with your employees, that will govern the overall terms. But even in choosing to terminate an employment contract, we always have to keep in mind our policies and procedures and what we're doing. Are we implementing them in a consistent, non-discriminatory manner? So with all of these new COVID practices, there's a lot of different laws that start flying around relative to the employment aspect of things. We're going to talk a little bit about employee confidentiality. We're going to talk about accommodating employees and that type of thing. But the key is that we always remember to implement these policies and procedures in a non-discriminatory manner. We're going to treat all employees the same way. Now, am I telling you to treat, for instance, a upper level executive who you may have the same as a lower level laborer? Not necessarily. Obviously, there's going to be some different things there that we take into consideration. What I'm telling you is we have to treat these people the same when it comes to when they fall into a protected class. We get all the time that, people will say, oh, it's such a hostile work environment. And the question is, well, why is it hostile? And they say, well, my boss is mean to me. Well, why is your boss mean to you? Well, he's a jerk. Well, is he an equal opportunity jerk? Because that's okay. If he's a jerk to everybody, I'm fine with that. It's when somebody is targeted based upon their status in protected class that I begin to question whether we are wading into some inappropriate legal territory. So this is just a little primer to remember that we are an employment at will state, but you cannot terminate or take an adverse employment action against any employee based upon these protected categories. So the first one is Title VII of the Civil Rights Act, which is based upon what many people think: race, gender, national origin, religion. Back this summer, the Supreme Court extended sex to include transgender and sexual orientation. So that has opened up a new class of claims that we're beginning to see that by people who may fall into this protected class. The next one is Age Discrimination and Employment Act. This applies to any employer with 20 or more employees, and you cannot discriminate against someone based upon them being over the age of 40. And this can be anywhere from promotion or from demotion to change of title. It does not have to be termination. Adverse employment action carries the gamut. So reprimand, what have you. So then the next protected class we'll look at is the ADA, which is you cannot discriminate against someone with a known or perceived disability. And this is probably the one that's most concerning for me relative to COVID. because we're going to have a lot of employees who are requesting an accommodation, or perhaps you perceive them as having a disability. Maybe you know they're a diabetic and therefore they are at a higher risk of exposure to COVID, and how we're going to handle those employees and make sure that we properly document in the event they are somebody that we either have to let go, or perhaps they feel like they have to leave because we're not properly accommodating them. That's another way employees tend to try and sue employers, is they basically say, I had to quit because they didn't give me a proper environment for me to succeed in. So that applies to employers with 15 or more. And then the next one is retaliation law. So under Tennessee law, there's something called the Tennessee Public Protection Act, which we'll talk a little bit about later. I actually have my first claim related to COVID and the Public Protection Act that I recently received. And basically what this is, the whistleblower case, which is saying that an employee is reporting some type of unlawful activity, unsafe environment, and after they reported it up the chain, nothing was done about it, and the employee faced an adverse employment action. My first one I've recently received related to COVID, and we'll talk a little bit more about it later. But this is also another concerning area that I think employees may be starting to target employers for either not implementing appropriate actions or taking adverse actions against employees who may complain or make some type of claim that we're not doing something appropriately. And then the catch-all here is other applicable state laws. So while a lot of the federal laws may not apply to you because perhaps you're a small design firm, you have 10 or less employees, or that type of thing, we're going to get you, because under state law, it has to be 8 employees. So there is a state law counterpart to every single one of these, and they are virtually identical to the federal law. So under Title VII, there's the the state law counterpart to Title VII for the sex, gender, national origin is what we call the Tennessee Human Rights Act. So if you have 8 employees, you are subject to those, and it's all the same recoveries. Why are these so concerning? The reason these are concerning is because while you may be a great employer and you of course would never discriminate against any employee based upon anything, the scary thing about employment claims is that a prevailing employee is entitled to receive his or her attorney's fees. So, and the jury is not made aware of this. So if you get a sympathetic plaintiff, and maybe they just feel sorry for her and say, this is a big employer, it's okay, she doesn't have any money, but we'll just give her $1,000. What they don't realize is they're not only giving her $1,000, they're giving her $1,000 and they're giving her attorneys $300,000. So this is not intended to scare you, but employment claims are very serious because but while you may have a CGL for just general liability issues, while you may have a malpractice professional liability coverage, many employers and many small employers do not carry EPLI insurance, which is employment practices liability insurance. So that's one thing to realize, is you may or may not have coverage for this. And I'm not intending for everybody to pick up the phone and immediately call their insurance broker, but this is something to always be aware of. And many of you may also be saying, well, we're a small firm, we've got 10 employees, nobody would ever do this to me. Yes, they will. When the employment situation goes south, it can go south very fast. So I'm not trying to scare anybody, but just always remember, these are what need to be in the back of our mind when we're implementing any policy or procedure, and especially when we're starting to think about new uncharted territory with COVID-related claims. So the first thing I want to talk to you about is COVID and the Americans with Disabilities Act. So this is probably one of the most important things we need to remember. So the Americans with Disabilities Act, you have to have 15 or more employees, but the Tennessee Disability Act is the 8 employee counterpart. And basically what this means is if an employee comes to you and says, I am diabetic and I am right now, I'm in Knox County. Many of you are in Middle Tennessee as well. All across the state, COVID is skyrocketing. All across the nation, COVID is skyrocketing. I anticipate that as these numbers continue to grow, you may have more employees who have crippled along, come to work, put on their mask, done what have you. People are going to start getting nervous again, especially if you watch the news, which I advise no one watch the news. But anyways, so what happens is when an employee comes to you with a concern, such as I am over the age of 50 or I'm over the age of 60 and I have diabetes and potentially other comorbidities that make me more susceptible to a bad case of COVID. I don't feel comfortable coming to work. Well, you as an employer may say, well, obviously this is probably pre-March. You as an employer may say, well, we've always done it this way. You're going to come to work. It is clear that after March, if your employees can telecommute and you can provide that as a reasonable accommodation, you better. Because I don't see any jury being sympathetic to an employer really putting his or her foot down and saying, you need to be in the office. Unless you can document performance-related issues relative to the employee, perhaps when they were telecommuting. But telecommuting is, in the past, before COVID, was a reasonable accommodation for a lot. Definitely is now. Now, many of you who may be contractors or subcontractors are probably sitting there giggling and saying, this lady's crazy. Of course we can't telecommute. We have, our people need to be boots on the ground. We're building things and we got to have them there. There are ways you can consider accommodating employees who have comorbidities. So you're not required to create a new position. The ADA specifically says you are not required to create a new position for this employee. But there are ways we can be potentially creative. For instance, you could you could say, what more could we do to implement some good practices? Put a sanitizing box in every work truck. Perhaps allow them to drive their own truck to the work site so that they're not in an enclosed vehicle with other workers. Or maybe putting everybody in specific cohorts to where they're not working with this subcontractor that day and this subcontractor the other day. They're supposed to be with these three guys and these are the three guys they're going to be with. So limiting potential exposure that way. So the number one thing you have to do when an employee comes to you with some type of concern like this is to engage in what's called the interactive process. This is box number one. If you don't engage in the interactive process with an employee, you might as well write them a check, because you are going to, and it's a per se violation. It is, you have to do it. So what the interactive process is it's just a back and forth between you and the employee. And so what I use this example a lot is, so I'm personally am vision impaired. And so I have, if I showed it to you, I have a giant monitor sitting right here next to me at my desk. I can go to my employer, my managing partner, and say, I need a new monitor. I need a 64-inch high quality definition, make sure it has cable monitor for my office. My managing partner will promptly tell me that what you shouldn't do this, but my managing partner would probably say, you're crazy, get out of my office. But no, what you need to do is you need to sit down and say, Caitlin, okay, well, that's great, but that's going to cost me $8,000, and that's not going to cut it. And it's not really a reasonable request. Instead, I'm going to give you a 32-inch monitor, standard definition. How does that sound to you? It's going to cost me $500. I just Googled it on Amazon. Okay. That's the kind of situation you need to have. I know it's a very simplistic view of what this interactive process looks like, but if it's a back and forth give and take as to what you can do as the employer and what the employee wants, and encourage the employee to provide you suggestions. Now, it's not everything's going to fit into a pretty little 64-inch versus 32-inch box here. I mean, this is more complicated than that. So what you need to do is you need to learn what the nature of the impairment is, the severity of the impairment, and, relate it to what they do every day. So, for instance, let's say, you have an employee who is given a very severe lifting restriction. Let's say they work for UPS and they have to lift, I think UPS drivers have to lift under their job description, something like 100 pounds. And they all of a sudden have a lifting restriction. Is it reasonable for you to have to go hire an employee to come help them on their daily route? Probably not. That's going to cost you a lot of money. So we always have to think back and forth as to what are the essential functions of their job that they do every day, and how can we accommodate it? We may end up coming to an analysis of we can't accommodate it. And then that's when we can get into whether there are potentially protected leave laws or PTO that they might be entitled to. So always look at the key functions of their job when figuring out what we can do to accommodate them moving forward. So keep those always in the back of your mind. So ADA issues. So you may have some employees who have some respiratory issues that cannot wear face coverings. You may talk to them about whether they could wear an N95 protected shield, a different ventilated mask that perhaps you as the employer could purchase. Maybe you could make sure that they are in, maybe you give them a solitary assignment, where you put them a place where they don't have to wear face coverings. Whether that be in an office environment or a smaller job site. Increase your cleanings. You can always offer that to employees. So I represent a lot of school districts. And when we were coming back to school, there were a lot of teachers that said, I don't feel very comfortable coming back. So we sat down with them and said, this is the protocol that we're doing. We are sanitizing every night. We are using this cleaner. We're using that. We're doing this. What more can we do for you? And honestly, after going through those interactions, many of them were comfortable with it. But you can always offer something, like would you prefer that we clean your workspace daily or hourly or what have you? Obviously, hourly would be ridiculous, but you know what I'm saying there. So then obvious increased separation at work. We can consider that. Telework is very clear. And then cohorts, which is what I said before, keeping people together. And that'll honestly, keeping people together in terms of job sites, depending on what different people's specialties are. If you can keep the same people together, what I've noticed from a lot of my employees is when it does come down to the exposure protocol, there's fewer people that have to isolate if they've been around fewer people, which is not going to tank your entire business. And then there's a lesser chance of multiple people getting infected. So I have one client that does a lot of electrical work, and they obviously in the electrical industry, you have apprentices and things like that for them to get their licensure, and their typical protocol is to rotate apprentices among master electricians to ensure that they're getting exposure to different people. During COVID, we've stopped that. Unfortunately, these apprentices are stuck with who they've got, and that's okay. But that way, we are not intermingling and potentially infecting other cohorts. So that's something to always consider if you want to think about that. So one problem that we run into is we can't assume that anyone is at an increased risk of exposure. So just perhaps you have an employee who is, who is obese, and you can see that they may be at risk of higher exposure. We can't necessarily assume that, because under the ADA, there's something called the perceived as claim. So the ADA protects employees who are disabled or who are perceived as disabled. So if you start treating an employee differently because you perceive them as disabled or less able to come to work because of COVID, you could be in a heap of trouble. So just make sure that you maintain those proper parameters. Now, am I telling you to be an ice queen and not stay in tune with your employees and their needs? No, but rest assured that once you open that box, you need to be prepared to offer them reasonable accommodations. So what we run into a lot with employee confidentiality, personnel files are typically something that everybody's like, okay, yeah, that's personal, that's confidential, I'm keeping that under wraps. But what always kind of comes into question is with health screenings, and especially since many of you are probably performing health screenings on a daily basis. I know I walk into my office every day, I go into a separate room, our HR lady here takes my temperature, I answer the 5 questions, it's recorded, and I come to my office. What is key here is understanding that you are taking health information of your employees. Now, are you subject to HIPAA? No, because you're not a healthcare provider, you're not creating a medical record, we're not worried about HIPAA violations here. But employees have an inherent sense and right to confidentiality of their employment records and anything that may be contained in their employment records, which would include health screenings. So one thing you should do is limit people who are doing the health screenings. This should not be a rotating basis where it's different people every day, just who happens to walk into the office first. Limit it. Make it somebody that you can count on being there regularly. Maybe make 2 people, make someone a backup. But you should not have multiple people, especially outside of a supervisory capacity, performing these health screenings and creating these records. Because what happens is loose lips sink ships, and we don't want your ship sinking because somebody breaches confidentiality. And you should, any employee that's undertaking these health screenings need to understand the importance of keeping these items confidential. And so any results of these health screenings need to be on a need-to-know basis. I would not suggest having these health screenings just in your lobby as people walk up the elevator or what have you. You just need to make sure that it's done in a limited manner to ensure the utmost confidentiality as we can. So another issue we run into is to exposure notifications. So clearly, if you have an employee who tests positive and they contact you, at least here in Knox County, what is happening is the Knox County Health Department is taking care of the contact tracing and saying, don't you worry about it. We're going to contact anybody that your employee identifies as a close contact. I don't agree with that. I think every employer needs to undertake some type of due diligence in their own workspace to ensure that people are notified if they have been in close contact. We cannot identify the employee by name. If you're in an office, a small office, it's not going to be too hard to figure out who it is, obviously, because we'll just figure out who hasn't shown up in 14 days. But regardless, you as the employer needs to make sure you're not the one that's spilling the beans. The employee can say whoever they want. These employees can have a conjecture as to who it might be. As long as it doesn't come out of the employer's name, I'm fine with it. So don't identify the employee by name, but do your best in your workforce to talk to that employee and say, who may you have had close contact with, which changes daily, but I think what the latest one is 10 or more minutes within 6 feet. It's vacillated back to 15 feet, sometimes 6 feet. So on the slide is a sample exposure notice, which basically just says, we have a confirmed case in our office of COVID-19. We learned that you may have been in close contact with this person. Contact your blank health department. Here's the number for further direction. So what this does is this covers us from the sense that We are maintaining a safe workforce in that we are letting people know who may have been exposed, and we are still maintaining employee confidentiality. If somebody comes to you and says, who was it, who was it, who was it, your bottom line is that's a confidential employee information. I cannot share that with you. I encourage you to contact the whatever health department to seek further directives. So where we come in here now is protected leave laws, which you all should know a little bit about these already. The Families First Coronavirus Response Act applies to any employer with less than 500 employees. What this did is it provided emergency paid sick leave and expanded FMLA leave. And the way you get this back as a private employer is through payroll tax credits later. So what is key here is if you do have employees that have availed themselves of this protected leave law, you need to make sure that you've appropriately documented it, gotten the necessary quarantine or isolation order from the employees, and that you are properly documenting it in whatever payroll system you have so that you can get this money back later. So what this provided is if an employee meets a qualifying condition, they get up to 80 hours of paid sick leave, and it's subject to applicable limits, which if the employee themselves is the one suffering from COVID, they get more money. They get up to $511 a day at their full pay rate. But if they make more than $511 a day, you're only going to get $511 back in your payroll tax credits. If it's as to the sickness of another employee or another person, they only get $200 a day and 2/3 of their pay rate. So then that's the paid sick leave. The paid expanded medical leave is they get up to 12 weeks paid, and this is only to take care of their son or daughter if their school is closed. What is key here is this is at 2/3 pay, and they don't get paid for the first 2 weeks unless they avail themselves of it under the sick leave law, which was in bullet point number 1 on the previous slide. So what we need to be aware of here is how to appropriately calculate this. Now, you may be saying to me, Caitlin, I've heard about this since April. It's set to sunset December 31. Why do I care about this? As you know, the Senate is currently considering a new stimulus bill. When I read what I can about the new stimulus bill, it appears to be to provide a second round of stimulus checks to Americans, as well as expansion of the PPP loan. I don't know if somebody's going to slide something in there expanding the FFCRA into next year. We know the virus is not going to sunset on December 31st, although we wish it would. So the virus is still going to be here on January 1. I don't know what's going to happen to the FFCRA. Guarantee you, if it is expanded, you will receive a blast from our firm telling you it has. I encourage you to make sure that you appropriately document, because you can get this money back through payroll tax credits later. So the next slide, Ashton. This is a little snippet from a poster. You should all have posted this in your in a conspicuous place in your break room or what have you, but this is the poster that advises employees on the FFCRA. So you can get that from the Department of Labor website. So I've put some factual scenarios here, and I think, so I can leave some time for questions. I'll just give you the bare bones of all of these and run through these quickly. So for the sick leave portion, there are 6 qualifying reasons. I've put 5 scenarios here in the hypotheticals. But basically, it's if the employee has COVID and they're subject to an isolation order, you owe them up to 80 hours, and they'll get their full pay up to $511 per day. They only get one set of 80 hours. So if they get COVID again later on in the year, they can avail themselves of PTO laws, or I'm sorry, other PTO. You cannot require an employee to exhaust their PTO. This is in addition to their PTO. And so you can't say, well, just take your PTO and FFCRA later. No, they are legally entitled to this now. So what we're going to what we have to think about is once they have exhausted their FFCRA leave, is there other accommodations you could provide them? Let's say if they get COVID again, accommodations can include additional unpaid leave. So you could consider saying, okay, we're going to accommodate you by letting you have 2 weeks off because you're subject to an isolation order. I do anticipate that that's going to happen, especially if Congress decides not to expand the FFCRA into the next year. So you need to be prepared. If your employee comes to you and says, I'm subject to an isolation order, I would be very reluctant to tell you to say, fire them because they're not showing up to work. That's not going to fly. I would not want to try that in front of a jury. No jury wants that COVID positive person showing up to work as much as any of us do. So just be careful on how you handle employees after they exhaust the FFCRA. You can go to the next slide. We need to remember too, this is a scenario where you have an employee who comes to you, she's 70 years old, has other comorbidities. Remember the ADA. If she could be entitled, if she's subject to an isolation order by a physician, she's entitled to that 80 hours. But the question remains, after that 80 hours, she's still 70 with comorbidities and she has a job with you. So let's talk about the ADA and how we're going to telework or provide her some type of accommodations to get her back into the workplace, or provided her an extended leave of absence. That's one way we can do that as well. Some employees I've had come to the employer, especially with the extra stimulus money from unemployment, they wanted to be laid off. So what I encourage you to do in these types of situations, if you have a question, reach out to your labor and employment lawyer. If that's Lewis Thomason, reach out to us. We're happy to walk through some pitfalls and maybe try to mitigate some risk as well. So the other 3 factual scenarios I have relate to the same qualifying reasons. So I won't belabor those. I'd rather talk a little bit about the Public Protection Act, which is right here. What I mentioned to you before is employees can bring forward claims for a whistleblower. So for instance, if an employee complains to you that proper PPE is not being provided to them, or they don't think you're doing things appropriately, they could bring a cause of action if you take an adverse employment action against them under this law. It's a high burden for them. They have to prove that the only reason you terminated them is because they complained about your COVID practices. What I encourage you to do is, if you have problem employees, make sure that you properly document those problems. The worst thing you can do for an employment defense lawyer like me is if you come to me and you tell me that I fired John and he's coming back now because he was a horrible employee, he had poor performance for the last 5 years, and you come to me and say, he's suing me because I didn't follow COVID and he complained about it. But really I fired him because he's a horrible employee. And I say, okay, well, send me his personnel file. And his personnel file has his employment application and his benefits package. Doesn't document any of his poor performance. In employment litigation, it's very important that, a document speaks 1,000 words, and the man with the most documents typically wins. So we need to make sure that we're documenting these performance issues, because I know none of you want to will discriminate against your employees, but it's going to be your burden to prove it if they allege that you have. So if you guys have any questions, do we have any questions in the chat, Ashton?
I haven't gotten any.
Okay.
If anybody has any questions, you can send those now.
And one thing I want to remind everyone is our next webinar is November 17th, like I said before. It's going to be presented by Preston Hawkins and Julia Hale regarding unlicensed contractors. I know we've thrown a lot at you today, and I really encourage any of you who have any lingering questions or may have a question they don't want to ask in the chat box. Our contact information is at the bottom of the slide, celam@lewisthomason.com and asmith@lewisthomason.com. Feel free to reach out to us if you have any specific employee questions or just general questions. We've generated various forms throughout the COVID crisis that we continue to use and manipulate and rework, and we'd be happy to share those if you have a need arise. So, Ashton, do you have anything else to add today?
No, just like I said, keep utilizing your common sense and reasonable policies and procedures. And like Caitlin said, let us know if you have any questions. We'd be happy to help.
It was a pleasure speaking to all of you today, and we thank you for your continued support of Lewis Thomason. And we hope that our attorneys are equally supporting you all, and we hopefully will be through this COVID pandemic by next fall and can produce our construction seminar in person. So God willing, we end up there and all end up there safe. So thank you all for joining us today, and we'll be in touch soon.